Assalamu alaikum. I'm Amina Haider, lecturer, Institute of Business Studies. I'm here with the screencast of Introduction to Business course. Course code is BS 111. This is lecture number 18, and the topic that is going to be discussed today is companies meeting. Let's move towards the topic. The topics that we are going to discuss today are shareholders meetings, directors meetings, and special meetings. So moving towards topic, a meeting is actually an assembly, or it is a gathering of people for the purpose of entertainment, or they are there for discussion or like. A meeting can therefore be defined as a lawful association, or it is an assembly or gathering of two or more persons by a previous notice for transacting some business. The meeting must be validly summoned and convened. Such gatherings of the members of the company are known as companies meeting. So there are certain essentials of a company meeting. You have to fulfill certain requirements to conduct a company meeting. Number one is that to constitute a valid meeting, there must be two or more persons. However, like we said in our previous lecture, that in the article of association you mention all the rules and regulation for governing a meeting related to directors, related to shareholders. So an article of association may provide for a larger number of persons to constitute a valid quorum, but at least two persons must be there to conduct a valid meeting. The next essential of a company's meeting is that the meeting or the gathering must be conducted as a lawful business. An unlawful assembly should not be called a meeting in the eye of law. Uh, so moving towards the next essential of a company's meeting, that previous notice is a condition precedent for a valid meeting. A meeting which is purely accidental and which is not summoned after due notice is not a valid meeting. We cannot call it a valid meeting. So a notice must be sent to the shareholder for conducting a meeting. The next thing is that for conducting a meeting, the purpose of the meeting must be mentioned. There must be a purpose for conducting a meeting. If the meeting has no definite objective, summoned without any predetermined objective, we cannot call it a valid meeting. In mentioning the essentials of a valid meeting, we said that the quorum must be fulfilled. By quorum, we mean that the minimum number of members who must be present at a meeting as a requirement of the rules. If the quorum is not fulfilled or in the absence of quorum, the proceeding of the company cannot be started. One thing that need to be mentioned, that if the quorum does not complete within half an hour of the prescribed time, the meeting will be adjourned to the same time, same place, and same date in the next week. But if the adjourned meeting also the quorum does not complete, the member present shall be considered the quorum. This is the pictorial representations of companies meeting. We can see that there are three types of companies meeting: shareholders meeting, directors meeting, and special meetings. Shareholder meeting could be further divided into statutory meeting. We can divide it into annual general meeting and extraordinary general meeting. Directors meeting can be divided into board meeting and committee meeting. Special meeting could be a class meeting or it could be creditors meeting. Moving towards our very first topic, that is the statutory meeting. This is the first general meeting of the company, and during the life of the company, this type of meeting is held once. The company gives circular before 21 days of the meeting. The company also needs to prepare a statutory report. So what is a statutory meeting? Like we said, that it is the first general meeting of the company. It is held once during the life of a company. Generally, it is held after a company is incorporated. Every public company limited either by shares or by guarantee must positively hold a statutory meeting as soon as the company is incorporated. So it is a mandatory meeting for a public company to conduct it within certain specified time. And by certain specified time, we mean that it should be held between a minimum period of 1 month and maximum time span of 6 months after receiving the certificate of commencement. So a meeting that might be conducted before a time span of 1 month, we cannot call it a statutory meeting. So a statutory meeting must be conducted between after a month and within 6 months time span. The notice for a statutory meeting should mention that when the statutory meeting is going to be held, so it need to have a specific date and time and venue where the statutory meeting is going to be held. When we talk about private companies, they are not bound to hold any statutory meeting. But when we talk about public limited companies, they are bound to hold statutory meeting with within the specific period of time. So there is a procedure for conducting a statutory meeting. For that, the board of director must forward a statutory report to every member of the company. Um, Statutory report is the report which is sent by the board of directors to all the members of the company, and this report must be circulated before at least 21 days before conducting the statutory meeting. Um, the statutory report must have the information like the number of shares allotted or their consideration for allotment. It must contain the amount of cash that is received so far. Um, if the board of directors has signed any contract, the statutory report must contain the particulars of that contract and their modification, if any. It also must have the names and address and occupation of the directors and other office of the company. So it is a complete comprehensive report for the joint stock company. So, like we said, that this report must be sent to the shareholder at least 21 days before the meeting. So, those members that are attending the meeting uh, may discuss the topics that are present in the statutory report. It must be mentioned that when you are conducting a statutory report, no resolution can be taken in that. That is the procedure that the resolution should be weighted and they could be passed on to annual general meeting or extraordinary meeting. The main objective of the statutory meeting is that to make the shareholders or make the members familiar with the matters regarding the promotion of the company, matters related to the formation of the company. So the shareholders receive particulars related to shares taken up, the money received, the contract entered, all in the form of report, that is the statutory report. In the statutory report, in the statutory meeting, actually, the shareholder also get a chance to discuss the business ideas. They are also given a chance to discuss different methods and future prospect of the company. Um, According to Companies Act 1984, a company may be subject to winding up it if it fails to conduct a statutory meeting or if it fails to submit a statutory report within the aforementioned period. However, the court may order the company to submit this statutory report and to conduct the statutory meeting and impose a fine on the person responsible for the default instead of directly winding up the company. The next is the annual general meeting. After the registration of the company is bound to invite the first general meeting within 18 months. Then the general meeting will be held every year. So, like the name suggests, the annual general meeting, it is a general meeting which is held on yearly basis. According to the Companies Act, all companies must hold annual general meeting at the stipulated time interval. The notice for an annual general meeting must contain all the particulars of the meeting. Um, the time to conduct the first um, annual general meeting for a company is 18 months. So after incorporation, or after receiving the incorporation certificate within the 18 months, it is essential for the company to conduct its first annual general meeting. After that, the time between two annual general must not exceed 15 months. So 18 months is the time span for conducting the first annual general meeting, and the time gap between two general meetings should not exceed 15 months. According to the Companies Act, a company is not bound to hold any general meeting till the first um, annual general meeting is held. Like, for example, they could not conduct the extraordinary meeting before the first annual general meeting is being held. This relaxation is intended for the company to set up its final report on the basis of longer period of time. Um, One more relaxation is that the registrar, with the registrar consent, the date of an annual general meeting can be postponed. Um, but they can postpone that meeting to a maximum time period of 3 months. However, this relaxation is not applicable for the first annual general meeting. In conducting the annual general meeting, they should state all the profits and all the losses earned and endured by the company from the day of its incorporation. They should also mention the updated account for at least 9 months from the date of last annual general meeting. So the annual general meeting is subject to certain rules that it must be conducted every year. The gap of 15 months is allowed between two annual general meeting. The meeting can be held at any time during the business hours. The day of annual general meeting must not be a public holiday. Not holding an annual general meeting according to the Company Act is considered a very serious offense in the eye of law, and the company can be rendered as defaulter, and they have to submit, or they have to fulfill certain fine that is imposed on them. The next shareholder meeting is extraordinary general meeting. This type of meeting can be held on any time. The directors or some shareholders can invite this meeting. 1/10 of the shareholders may give the requisition to the board of directors to arrange this type of meeting. After getting the requisition of board of director, if the board of director fail to arrange a meeting within 21 days, the shareholders can invite the meeting within 3 months. So all general meetings of a company, uh, other than the annual general meeting and the statutory meeting, shall be called an extraordinary meeting. Uh, the extraordinary meeting can be convened by the board of directors, or they can be convened by the requisitionists themselves on the failure of the board to call for a meeting. However, the meeting must be held in accordance with guidelines that are mentioned in the Article of Association of the companies. So, this is the type of meeting that can be called by the board of directors, and that can be called by the members or the shareholders themselves. So, if some business of special importance requires an approval of members of the company, the board of directors may call for an extraordinary general meeting of the company. Going in accordance with the Article of Association of the company, the board of directors of a company may call for an extraordinary general meeting whenever they feel appropriate, or whenever they feel that an agenda um, could not be waited for an annual general meeting. They can call an extraordinary meeting. The power of director to convene an extraordinary general meeting must be exercised at a board of directors meeting, as in the case of all the powers exercised by the director. Like we said, that the shareholders or the members could also request for an annual general meeting to be conducted. But the shareholder, but they can be, but the members that call for the extraordinary general meeting, they must hold at least 10% of companies' paid up share capital, and having the right to vote on the context of the matter to be discussed at the meeting. So, if the directors fail to call for the meeting within the 21 days of requisition for a meeting, um the shareholders can themselves then call for a meeting. And this kind of meeting must be called within 3 months from the date where the requisition is filed. And these kinds of meeting has the same procedure to be conducted like the board meetings. Now we are moving towards directors meeting. So in directors meeting, the first is the board meeting. The company is bound to arrange the meeting once in 1 month and at least 4 times within a year. Quorum is filled by 1/3 of the directors present or at least 2 directors present. So meeting of directors are called board meeting. These are the most important as well as the most frequently held meeting of the company. For conducting the board meeting, they must be conducted at least once in every 3 months, and at least 4 such meetings shall be held in every year. Or, in other words, we can say that no 3 months should pass without the directors' meeting being held, and no year should expire without at least 4 directors' meeting having been held in it. The objective is to ensure that the board meeting are held at reasonably frequent interval so that the directors may be in touch with the management of the affairs of the company. Uh, the directors meeting must be conducted with an agenda. The term agenda meeting the things to be done. In the present context, it is a statement of the business to be transacted at a meeting. So, in the board meeting, uh, the board can call for issuance of shares and debentures. They could make calls on share. They could discuss about the transferring of shares. They could discuss about fixation of rate of dividend. They would discuss whether to take a loan, or they have to take decisions about the loan if they want it in for the company's prosperity. They would decide about how they are going to invest the wealth of the company. They would discuss the difficulties that are faced by the company, and they would determine the policies of the company. Committee meeting. The board of directors sometimes makes special committee to complete in any special work among some directors of the company. So the board of directors may form certain committees and they may delegate some of its powers to them. These committees should consist of only directors. The delegation of powers to such committee is to be authorized by the Article of Association and should be subject to provision of Companies Act. Um, in companies, routine matters like allotment, transfer, finances are handled by subcommittee of the board of directors. So such type of committee meetings are held in the same way as those of the directors meeting. So in the creditor meeting, the directors or their appointed lower can invite this type of meeting if necessary to construct or to dissolve or to any amalgamate the company to preserve the rights of the creditor. This type of meeting is invited by their proper authoritative person. So, strictly speaking, these are not the meetings of the company. They are held when the company proposes to make a scheme of arrangement with its creditors. Companies, like individuals, may sometimes find it necessary to compromise or make some arrangement with their creditors. In these circumstances, a meeting of creditors is necessary. This is the book that I followed for today's lectures. That's it for today. Thank you.